Good morning. I wanted to talk to you today about situations where there might be multiple people who want to administer an estate after somebody passes. So, this is a situation where there's maybe no trust and no will. And as such, there's not clear instruction from the decedent, from the dead person, on who they want to manage their estate. Because if they had a will, they would name an executor. If they had a trust, they would name a trustee. Here, that's not the case. And sometimes multiple people can file petitions to be appointed as what's called an administrator. In this instance, they would be seeking their appointment to marshal the assets, prepare assets for distribution, and generally manage the responsibilities of the estate. So there's sort of a few different ways that this happens. The first is that there might be people of differing levels of relationship, and the code provides for priority for different levels of relationship. So if a spouse applies and a sibling applies, the spouse is priority. And there's a significant list that includes many different types of family members, parents, grandparents, nieces, nephews, cousins, etc., and even other types of people who don't have any relationship, such as a creditor. Creditors have some priority. Theirs is the absolute bottom of the list, but they are listed as someone having priority. So that can be pretty straightforward because, like I said, if a spouse petitions and a sibling petitions, and I have a case like this right now, in fact, the spouse is priority and the sibling would be foolhardy to continue with their petition unless they have some evidence that the spouse is going to do something inappropriate or could not act appropriately, like they lack mental capacity or something, or under undue influence of somebody else. Those are more straightforward. It's when people of the same relationship apply that it can get more complicated. I've had cases where cousins apply. I just appeared recently on a case where two siblings applied and were fighting like this to see who was going to be the administrator. Sometimes there can be a co-administrator, but that can be problematic because you have two parties that are in disagreement or fighting or have antagonism, and they're supposed to work together. That creates problems, as you can imagine. So when they have equal priority, then there's usually a few different ways that it goes. One is people start flinging nasty allegations against each other. So they might say, you should pick me because my sibling committed elder abuse. Or you should pick me because my sibling never loved mommy the way I loved mommy. This can get really unfortunate. Sometimes they try to promote themselves. They say you should pick me because I am a realtor, or I am an attorney, or I am this or that, and I've been very successful, and I'd be better than my brother or sister who is a nobody. That's usually not as relevant because the court's not looking to see who has the best profession, who might be this type of job or that type of job. They just want to see who's going to do a good job as the administrator. In those instances, when maybe there's not clear-cut obviousness as far as who should be the administrator when it's the same level of relationship, oftentimes parties just settle the matter by going to a neutral professional. These can be a professional administrator, and they would get paid out of the estate. They would bring an attorney who would get paid out of the estate. That's based on the California law. People don't like to do this because they don't want to give the estate away to professionals, but the litigation costs can often be quite high compared to just settling the matter quickly and having a professional handle everything. This is especially true because if they're fighting over who's going to be the administrator at the start, that often means they might be fighting over future issues like how to sell a piece of real property, how to manage a litigation or a claim. And so ultimately, even if this litigation is expensive or settled, there might be future litigations, and bringing a professional can avoid all of those across the board and have significant savings. So those are some of the different ways that it's determined what's to be done if there are multiple petitioners seeking administration of an estate. And that's why it's so important to set up a will or a trust, because if there's clear nomination of an executor or a trustee, then this whole situation is avoided and fighting is minimized, litigation is minimized, and most importantly, attorney costs, fees are minimized, which means more money for the beneficiaries and less money for attorneys. Thank you.